Hello, professionals. My name is Donna Edwards, and I'm going to provide you with some continuing education units so that you can continue to work in your profession with some enhanced knowledge. I am a certified addiction treatments counselor 4 who is accredited by the Addiction Counselor Certification Board of California. I have worked in this profession for over 20 years, and I am a CEU provider approved by CATIE, California Addiction and Drug Educators. Let's talk about ethics and confidentiality. Confidentiality. Information regarding a person's substance abuse history is federally protected to encourage those needing treatment to seek help without fear of repercussions. Confidentiality and privacy. There are several rules that apply to participants in drug treatment centers. Clients are protected by 42 CFR Part 2, the Alcohol and Substance Abuse Treatments Confidentiality Rule. HIPAA is a new federal rules covering all health-related information. The regulations governing confidentiality of alcohol and drug abuse patient records. First issued in 1975 and revised in 1987. It was designed to help deal with the stigma of addiction. It requires notifications of confidentiality, consent forms, prohibition of redisclosure. I'm sorry, I cannot acknowledge whether someone is or isn't in the treatment program. It imposes restrictions upon the disclosure and use of patient records that are maintained and connected with performance of any federally assisted alcohol and drug abuse program. There are fines associated with infractions of this regulation. If the client requests that substance abuse staff participates in case management while in treatment or during the aftercare phase, an authorization to release information will be completed and kept on file. No information regarding a client will be released without a signed authorization to release information. When information is forwarded to another agency, it must contain the following prohibition. The disclosure. This accompanies a disclosure of information concerning a patient in an alcohol drug abuse treatment made to you with the consent of such patient. This information has been disclosed to you from records protected by federally confidentiality rules 42 CFR Part 2. The federal rules prohibit you from making any further disclosure of this information unless further disclosure is expressly permitted by 42 CFR Part 2. A general authorization for the release of medical or other information is not sufficient for this purpose. The federal rules restrict any use of this information to criminally investigate or prosecute a client or patient. Releasing information. Here are the rules. Rule number 1. Don't release any client information to anyone. 3 sets of exceptions. the client consent authorization, when rule does not apply, communication to internal to agency, crimes on the program premises or against agency personnel, qualified service organization agreements, and reporting suspected child abuse or neglect. When the rules don't apply, if there is a medical emergency, research, audit, and evaluation. Court order authorization, disclosure, and use. Subpoena is not the same as a court order. Elements of informed consent. Name of client. Name of organization to make the disclosure. Name of organization to whom information is being disclosed. Kind and amount of information to be given. Purpose of the disclosure. Statement that consent may be revoked at any time except as already relied upon or criminal justice system consent. Date or condition when consent will terminate. Client signature and date, or signature of minor's parents or other authorized to sign in lieu of clients when necessary. Signature of staffing assisting clients with release. HIPAA, Health Insurance Portability and Accountability Act of 1966. It was designed to ensure maintenance of health insurance coverage when you change jobs. Administrative specification, healthcare process becoming very complex. Look to standardize information. It makes it easier. Protect confidentiality and security of patient information. Is your drug court a HIPAA-covered entity? PHI, Protected Health Information. TPO, Treatments, Payments, Operations. NPP, Notice of Privacy Practices. Identifies the client's health information. Any information that is oral, written, electronic, created, or received by a healthcare provider, health plan, public health authority, employer, insurer, or others relating to the past or future physical or mental status, healthcare, and payment for such services. These are protected health information components. Information received from another covered program cannot be released. Information we release cannot be re-released by others. Each disclosure must be accompanied by a statement that clearly says this exact language is in the rule. These are some issues. Notice of Privacy Practices, NPP, Patient Rights, Right to Request Restriction of Users and Disclosures of Information, Right to Access PHI Protected Health Information in order to inspect and/or both copies, Right to amend PHI, Right to accounting of disclosures over past 6-year period. More issues include an arrest warrant or subpoena are insufficient to obtain client's information. It requires also a court order or consent. Responding to a subpoena. Is a person a client? Is there a consent? Then decide how to manage the situation. The burden is on the organization not to disclose client's information. Other issues include documentation of releases. When entity releases information to EMT in a medical emergency, police in case of crime on the premises, child abuse neglect reports, prevent harm, court order, all must be documented in chart. When we release information in response to any request for information, we should document what was released. HIPAA issues. Information received under promise of confidentiality is not subject to client right to access of records. Confidentiality of client PHI assured through secure transmissions, email, secure, or fax. Programs must determine the identity and authority of person requesting PHI before it is released. Common security violations that threaten confidentiality, inappropriate management of used ID, password, computer equipment. X. Leaving terminal turned on or unattended. Sharing use ID and or password. Requesting others to use their password. Posting a password example on a sticky note. Common security violations. Revealing a client's information, unauthorized disclosure of PHI. Misuse of internet, email, fax, mail systems to send PHI to individuals without a right to know. Obtaining PHI about clients for other than work-related need-to-know reasons. Practical safeguards. Do not leave papers containing PHI lying around where others can see them. At end of workday, clear a desk or other exposed areas of PHI and place in a secure location such as a file cabinet or desk drawer. Do not talk about patient PHI in public areas. If you take work home, don't leave it in a place accessible to people not agency employees. Keep locked in a briefcase or in car trunk. HIPAA versus 42 CFR Part 2. The laws cover a lot of the same material. Some points of difference, more specific or more recent rules usually applies. For the CD treatment providers, in most cases, the rules of 42 CFR Part 2 are more stringent. In several cases, HIPAA wins. Do these laws apply to drug court practitioners? How do we know they apply? Is the drug court program a treatment program for the purpose of the confidentiality regulations, and why? The general rule of disclosure. Treatment programs may only release information or records that will directly or indirectly identify a drug court participant as a substance abuser or treatment patient. with a knowing and written consent from the participant and other expectations explained earlier, other exceptions that were explained earlier. A proper consent can authorize all parties involved in the drug court to share information necessary to monitor treatment progress and compliance. To be effective, the consent form should be signed at the earliest possible time. Judge, coordinator, probation, etc. should get consent and fax it to treatment before the first appointment. Requiring consents. HIPAA prohibits a program from conditioning treatments on a patient signing a consent, but the judge, probation, parole, child welfare can condition participation in drug courts on the defendant signing the consent form. Ethical behavior requires more than a familiarity with the profession's code of ethics. Counselors also need to develop a personal ethical sense that involves reflection and insight in assuring the best possible service delivered to their clients. Process model for ethical decision making. Sensitivity to the moral dimensions of counseling. This includes not only professional ethics, but also personal principles and philosophy consistent with the profession. Identification of the type or category of dilemma, alternative courses of action. Referral to the Code of Ethics and professional guidelines for ethical decision-making, examination of the relevant federal and state regulations and case law for additional guidance, examination of relevant ethics literature for perspective, application of fundamental physiological principles and theories to the situation, consultation with other colleagues about the dilemma. Deliberation through which the counselor considers alternatives and develops a plan of action, informing appropriate persons such as supervisors and implementing the decision. Reflection on the action, which allows counselors an assessment and affirmation of their ethical decision-making process. Thank you for watching the video. Next, you'll be taking a quiz. Once you pass, you will receive a certificate of completion with your CEUs that you have earned. My valid provider number will be on your certification for you to turn into your certifying body.